Hi, everyone. So we'll be starting in a couple of minutes, just so we wait a bit for people to join in, and then we will start. Okay, so I think that we can start. So welcome to another of our Simplify webinar series. So from Simplify side, I have with me also Ivan, our CEO. He shared also some of interesting topics in our previous webinars. But today we are very happy and honored to have a very special guest with us. And it's my pleasure to introduce Professor George Krivokapic from our University of Belgrade, which is Faculty of Organizational Sciences. And Professor Krivokapic is really like a renowned expert in this field of law regulation, especially now with this artificial intelligence growth that we're having and facing today. And he helped us as well, to understand how is this going to impact our work and also the industry. And that is something that we feel it's like very valuable insights and important to also share with you people, so you are aware of the things that you should be concerned when it comes to entering this journey of artificial intelligence. So yeah, we're incredibly fortunate to have him today. And yeah, so welcome, Professor. And if you can give us like a brief introduction from your side, a bit about yourself, and then we can start with our today's topic.
Thank you very much. It's very nice to be here. Thank you for the invitation. I'm George Krivokapic. I'm a lawyer. I teach mainly topics on business and IT law, ethics, law and ethics. And I'm quite for some time in the area of technology, especially, and compliance. So I'll try to provide you an overview of AI Act, just to provide some first why we have this new regulation, then what is the regulatory approach, and what are some necessary steps we all should have in mind when we discuss compliance and ethics regarding artificial intelligence today. So if I can start, I'll go with my presentation. So it's important to understand that AI is all around us at the moment, and there are many opportunities we can utilize AI for different purposes. And we have this incredible case in Serbia that some 6 years ago, our Ministry of Internal Affairs decided to buy thousands and thousands of smart cameras for biometric surveillance of public areas, because they thought it's a great opportunity to reduce criminal in the public spaces and so on. But what they didn't know at the moment, they didn't think about that practically these kind of devices and this kind of smart system on our streets will maybe also have a really strong impact on our fundamental rights, not only on our right to privacy, but also our rights to freedom of expression, our right to freedom of assembly, right to protest, and so on. And due to all these reasons, this system never got into the work, and this question of biometric surveillance in public spaces became one of the important topics in a discussion of AI Act. So it's important to approach the implementation of technology from different perspectives, and especially when we talk about smart technology, which has various levels of artificial and machine intelligence. especially at the time when the point of singularity is close, we really have to be careful. So at the moment, we are at the stage of setting boundaries in this area, and it's completely clear that we need to protect fundamental rights because they are something what is provided to citizens by constitution, and then establish ethical application of AI, but also for market reasons. We really need to improve trust in technology, and also for all the manufacturers and implementers of technology to ensure legal certainty, what kind of technology is allowed, in which context, and have really clear rules so we can really invest in R&D and implementation, not to be in a situation that we put technology into work and then we get into a situation that that is maybe not allowed. And in general, there is in general public, there is a misconception that artificial intelligence is not regulated and technology is generally not regulated. Although we had this period of liberal approach to regulation, we have to understand that there are many different regulatory frameworks applicable to AI. So we, for example, have general regulation in the field of criminal law and civil law, like damages. So AI and the user of AI and the manufacturer of AI could be liable for example, a loss of life of someone due to AI action, for example. Then there are also sectoral regulations like telecommunication or finance or energy. And in many of these sectoral regulations, there are some specific norms and regulations regarding automatization of processes and potentially on use of AI. Then on the next level, there is a horizontal regulation. Horizontal regulations are applicable to all sectors, like, for example, data protection, cybersecurity, non-discrimination, and so on. And these regulations are really easily applicable to various applications of artificial intelligence. Then it's quite possible that we have some AI targeting regulation. What is AI Act? And we'll talk about that later, but in some countries there are also other regulations in that area. And then we have these soft layers like ethical codes, internal policies regarding the use of AI, and of course technical rules and standards. And at this point, before we go to the AI Act, it's important to emphasize that there are ethics guidelines for trustworthy AI already applicable within EU for the last couple of years. And they're really helpful as a first step of, let's say, approaching implementation of AI in any context. And for example, Serbia also adopted the similar guidelines based on European ones. So in general, there is already accountability framework, which can be, let's put in three different dimensions. First, there is a liability and accountability for non-compliance, and there are many fines which have to be paid usually to state and which are surveilled by various independent bodies like data protection commissioners and so on. So if you are not compliant, you will have to pay fine. Maybe even your business operations will have to be stopped for some period of time until you fix the problem. Then there are damages. So if your operations, which have some AI component, produce some damage to third party can claim that damage back. And of course, what is really important, there is a high reputational damage for non-trustworthy use of AI technology. And we know all that the consumers and citizens, of course, are really sensible for all these issues. So when you go into the landscape of liability, we can find cases which are only in one of these three areas, but we can also find cases where there are, for example, all three areas of liability are pushed in one particular case or two of these. So there is already a liability there on the ground. So the question then was in front of the European institutions: is this framework enough? Do we have enough rules to govern this kind of technology? And this algorithm is providing some really simple explanation to this question. Does law speak on this issue of AI? Practically, yes. Is it satisfactory answer? The conclusion was not really. And then there was an option for easy fix, like some easy regulation, adding some additional ethical rules or smaller regulations and so on. But again, there was analysis that there is no easy fix, that the risks arising out of use of AI, especially towards fundamental rights, are really high. And that's why the European institutions decided to go for legal disruption and create harder regulation. And that harder regulation is, in fact, the AI Act. It was negotiated last couple of years. As we can see, it came into the force this June. So we are, it's coming into the force this June. So we are right at the beginning of the life of AI Act. And it will become applicable in next 2 years in different phases. So, for example, what are prohibited practices, they will enter into fully become applicable at the end of this year, while other stages and obligations to providers of AI systems will come into the force and application later. So let's see what are the basic elements of AI Act. First, the scope of AI Act, material scope, are AI systems, and we'll explain them later. The approach AI Act is taking is human-centered, so fundamental rights are really important, but it's risk-based. So there are different rules based on a risk assessment. And there is ex-ante conformity, so all the actors, and we can see here who are the actors, and I'll explain them later, have to do ex-ante conformity before they put the AI systems into the market. There are really high sanctions, up to 30 million euros or 6% of turnover of the group of the companies on global level. So we already saw these similar sanctions in GDPR. There are sanctions going up to 1 billion euros. Due to this percentage option, and GDPR goes up to 4% of turnover. This could be higher, it's up to 6%. So it's really a critical risk for many organizations in this field. So they really have to take special care of compliance in this area. So as I said, the scope of application are AI systems, artificial intelligence systems, but also products with artificial intelligence systems as a component of the product. And we'll see a bit later which products are assessed as high-risk products and require a higher level of compliance. Also, what is quite new in AI Act is the new definition of artificial intelligence systems. It's based on new OECD definition, so they are really mirroring each other, not 100%, but they have all the same elements. And what are the elements? Before elements, just to explain that it was really goal to create the definition which is technology neutral, comprehensive, future-proof, and legally secure. So it's I'm not sure it's really easy for everyone to understand, but over the time it will become better for interpretation. However, it has a clear element. So AI systems are systems which are based on machines, so machine-based systems, which have varying levels of autonomy and may exhibit adaptiveness. So autonomy and adaptiveness are, let's say, new elements in this definition, because those are practically the characteristics of the people. And now we are providing these characteristics to AI systems. So AI systems after perform different operations, and for explicit or implicit objectives, they infer from the input they receive to generate outputs. Such are predictions, content, recommendations, or decisions that influence physical or virtual environments. So let's go once more. Machine-based systems, which have different levels of autonomy and adaptiveness, and when provided with objectives, they infer from the data they receive in order to generate outputs, which are classified on these 4 levels, and these outputs then influence physical or virtual environments. So it's important to understand that, like regular smart systems or for example, different types of automatization of processes doesn't need to be artificial intelligence systems, because they need to have some level of autonomy. They should exhibit some adaptiveness, and they have to work based on inputs they receive. So that's on a material scope. On territorial scope, of course, this has similar regulations of EU. This regulation has extraterritorial scope. So it applies to all manufacturers, providers of AI systems from EU, but also applies extraterritorially to any provider or distributor of AI whose services or products reach EU market. But also, it can include providers and users of AI system outside of EU if the output of AI system is used within the EU. So there are like 2 different tracks of extraterritorial applications. So even companies from Serbia or some other places could be obliged to comply with this regulation if they have business interests in EU. So who are the actors to which the AI Act is applicable? Those are mainly providers of AI system, but also sometimes importers, distributors, and of course users. Who is not within the scope? That's military. Those are citizens using AI systems for personal use, and also there are wide exceptions for research and development activity regarding AI systems. But we should we should put into the focus that providers or manufacturers of AI system are the main point of regulation. And then this is just one example of AI process flow where we have different phases: design, development, evaluation, operation, and retirement of AI system. And we should be aware that compliance with the AI Act has to be performed through all these phases. So we have to have capacity, and we have to think about compliance from the beginning, from the moment we think about the purpose of the new AI system we want to create until the end. But the steps which are provided in AI Act can be summarized in different manners. So we'll go just through the steps at the moment. So first, what is important to do? First, it's important to identify really within your portfolio all AI systems and AI-based products in order to be able to initially assess risks. When you initially assess risks, you'll be able to classify AI systems into different levels of risk. Why is that important? Because each level has different route. And now we'll talk about the level number 3, where we have high-risk systems, because main focus of AI Act are high-risk systems. Regarding high-risk systems, you need to design AI system in line with the requirements provided by AI Act, and I'll talk more about them. Then perform conformity assessment for people from quality management. This seems, I suppose, familiar. And then you need to fix CE marking on the product. Then the product is ready for the market, but you need to register some of AI systems also, and then perform continuous monitoring. So those are practically the steps, and how to be able to identify risks related to AI systems. You need to understand practically these 5 points. First, you need to understand what is domain where the AI system is applied. For example, is that HR services, or is that management of critical infrastructure, or is that sending marketing activity, for example. Then you need to determine what is really the purpose of AI system. What does it do? What kind of function does it have? Then what is underneath technology, and what are its AI capabilities? Who is the user of the system? Who will use it eventually? And then who is the subject to which the AI system will be applicable and its outputs. So when we are assessing risks of AI system, and of course risks within the framework of AI Act are understood as combination of the probability of an occurrence of the harm and the severity of the harm. We classify them, as I explained previously, on 4 levels. And on the top level, there are unacceptable risks. And those risks are really harmful, especially to citizens. For example, we can talk about some using AI for different kind of subliminal techniques, then creating of social credit systems of general purpose, or in general biometric surveillance on public spaces, although there are some really narrow exceptions. So in 6 months, if anybody has in operation such a system, it will be fully liable for under the AI Act. So these are no-go areas. Then on the 3rd level, we have high-risk AI systems. And these are AI systems, as I explained, which require really a strict compliance process. And then on a 2nd level, there are limited risk systems. And there are various transparency obligations, but on this level, but it's not so strict. And then eventually there are also minimal risk systems, which are also in a way out of the scope of AI Act, because AI Act does not provide many rules in their respect. As I explained, the focus is 3rd level, high risk AI systems. And here you can see one research output, which helps you understand what are really the domains and purposes and capabilities of high-risk AI systems. So in Annex 3 of AI Act, which will be expanded by Commission over the time based on their risk assessment, at the moment we can see what are the areas of high-risk AI systems. And those are administration of justice, critical infrastructure, educational, vocational trainings, employment, public services, law enforcement, and migration and border control management. And then not all the areas, all these domains, application in all of these domains is high-risk system, but only certain purposes. For example, what will be really important for many organizations, like allocating tasks within HR segment by AI system is high risk system, so it has to go through the in-depth compliance. Also, there is a list in Annex 2 of different, let's say, products which could have AI component, and if they have these products have AI component, they're also high-risk systems. And though this is famous list, and I think most of you are familiar with it. So if these products are, for example, recreational crafts or personal watercrafts, toys, children toys, or medical devices, or different kind of vehicles or planes, or similar kind of smart equipment, if they have AI system as a component, either as a security component or some kind of optimization component, these systems are also considered high-risk systems. So these high-risk systems have to be designed in line with the requirements, and in short, that means development of AI system which is overseen by inclusive multidisciplinary team involving when relevant experts and external stakeholders, which take due in consideration both technical knowledge, experience, education, and the training of user and deployer may need, and also which are capable to manage risks and enable transparency. So this is like very broad approach. But what is really the assignment? The assignment is designing AI system in line with essential requirements which are not directly defined by AI Act, and that's very specific in this situation, but they are, let's say, they leave some flexibility, and they really rely on standards. So in practice, the main task of any provider would be to really establish risk management system in this respect, risk management system for identification, estimation, and evaluation of different kind of risks, and adoption of suitable risk management measures. Risks are not only, as we said, health or safety of natural persons like before, but also fundamental rights. When we say fundamental rights, we think about EU Charter of Fundamental Rights. So it's a catalog of various human rights which are guaranteed by EU, including equal access and equal opportunities, democracy, and rule of law. So there are different things. And also risk management system should have appropriate measures which could prevent foreseeable harm, eliminate or reduce identified risk, mitigate and control measures, and provision, of course, of required information. It's obvious, but these risk management systems can be integrated in already existing quality management systems within organizations. So they should be considered as add-on to existing systems. So what's clear then, we have essential requirements established by AI Act. Then there will be developed harmonized standards which could be used in compliance process. then there should be performed conformity assessment, and after conformity assessment, CE marking can be added to the product and it can be delivered to the market. What are essential requirements? There is 7 of them. First one, as I explained, establishment of risk management system. Then there are many different, very specific issues and requirements related to data quality, data which are input for both creation of the model, but also operation of AI system. Then there are many requirements in area information security. Human oversight, of course, is really important, both to be able to assure the quality of operations, be able to take the overview, but also stop the operations of the system. There is a robust system of technical documentation which is involved. Many logging features are necessary in that respect, and of course, transparency of all these requirements and other types of transparency like explainability and interpretability are put into the place. So I will probably stop here and provide the opportunity for even to reflect on standards a bit, and then I can conclude with a couple of more points.
Thank you, George. This was really amazing. So, like, putting all these things in such a short period of time and try to explain this complex topic. So, like, I wanted to add a little bit about AI management system or ISO 42001, which is actually an essential part of EU Act. And these two things are like totally interconnected. So we have like one standard now that's like, we can say brand new, but it's like from December last year that is becoming mandatory if you want to have like your products into the EU market, or if you want that your product or service that have any kind of AI inside itself will be used in EU. So it kind of changed the game because, like as we know, management system standards are actually not mandatory. But this time when we have a law that is actually complying and like having all those requirements inside it, and it is becoming fully like mandatory. So like I want to say just a few things. So like 42001 is like as any other like global recognized standard, and it offers systematical approach to this topic and how to use AI technologies, and it should address all those topics that we mentioned here that are covering like risks in ethics, accountability, transparency, and data privacy. So what is new and different if we compare this to other management system is that it's kind of similar to ISO 27001, where we have Annex A as a controls that needs to be understood. Here we have Annex A and we have Annex B. In Annex A we have 38 controls, and in Annex B we have 38 guidelines that are actually explaining us or how to use these controls. And those controls are mainly regarding all the things that were mentioned before, like the data, the life cycle of AI system, and especially risk assessment and treatment of the risk. So it's purely risk-based standard. And when you assess risk, you need to understand how you treat it and how you actually put all these things in a market. So as you said, like we have like 2 years maybe for this, but as we are putting this into design phase, and if this starts to get like if we see that the AI market is really growing, so we really believe that any company should actually at the start do the gap analysis and understand where it is comparing to the requirements of this ISO 42001, especially if the company is already using 27001 and having like management system or systems. So most of the requirements are there. Just we have these new controls that are actually covering all those requirements that you mentioned. So we kind of need to understand where we are and how we can move together, considering the standard and what we have in the EU Act and all other requirements in order to actually sell and do our business inside the EU. So you mentioned a few times process automation. We are like actually in that business. So we are always assessing now if there is a need to use AI for automation of certain processes. If not, we continue. If there is a need to use AI, then we actually need to implement all those requirements inside the standard, starting from the data and how we are gathering data and where the data is from, and all others in order to actually have it applicably presented not just in our market, but in all markets that we are operating. So we are like in 35 minutes, so I don't want to take more time. If there is any questions regarding the standard itself, I will be here to answer, but this topic today was about EU AI Act, so I will get back to you, George.
Thank you. So to conclude, in a way, it's quite a novel area that standards will be used for protection of fundamental rights, and this will be the trickiest part of AI Act. So technical community in a way will be responsible to establish these standards, and of course there is a high burden of all the actors to whom the AI Act is applicable to comply on their own. So there be different also levels of surveillance of this activity, not only by government actors, but also by different civil society organizations, consumer organizations, and so on. So it will be a new field, and everybody are looking really carefully into it. To conclude, there will be for all the organizations who are especially developing AI, but also using AI in their operations, not solely as a from-the-shelf solutions, but also adding some additional purposes and adjusting it to its business processes, there will be a really significant impact on them. So they will have to adjust their product development process according to the requirements provided by AI Act. They'll have to develop capacities of organization and administration, especially to note down and create the evidence of every step they are taking in order to be able to comply with the regulatory framework. But not only this AI Act regulatory framework, as we explained, there are many horizontal regulations which will be applicable, like the GDPR and InfoSec regulations, and especially anti-discrimination regulation, which will go hand by hand. So the organization has to build different capacities to be able to be in the game of development or let's say novel use of AI systems. And here there is, from one research project, there is a model how to do compliance, and we can see that on the upper hand there is an AI system with all its characteristics, which has to be outlined in order for the process to be successful. So we need to know both the purpose, domain, capability, techniques, outputs, who are provider, user, subject, and so on. And then there is a risk assessment process to assess risk, resource, determine consequences and potential impact, and then create a reduction, a minimization, or elimination of the risk. And example which we will use here is example of an AI algorithm used by Uber. This algorithm has purpose. So Uber is practically the user and developer of this system with the purpose for biometric identification of drivers to decide on contract termination. So there are many legal requirements in different jurisdictions that that user guarantees that the driver has a driving license, for example, and so on. And for that reason, Uber has to identify the driver. So at the process, at the beginning, when the driver enters into the car and wants to make a ride, it has to be identified, and it's done by biometric identification. So this application is in domain of employment. The technique used is machine learning, and facial recognition is really the application of this technique. And the output of AI system is the decision about driver's access to work, because if he's identified as a person which already in a database have all the requirements to perform the job, he'll be allowed to work. He will be provided with a drive. What's the risk? Risk is inaccuracy in identifying drivers. So for some reason, I go to work to drive my Uber, but biometric identification creates some mistake and cannot identify me, and that's why I am really put out of the work. There is an impact of unfair dismissal of a driver. What is the risk source? Risk source is different biases in algorithmic training and different inaccuracies in that respect. And in this situation, we need to take a measure. What would be that measure? The measure which can mitigating event is manual review. So in an event that I am not recognized by the algorithm, I am provided with the opportunity to object. My objection goes through the system to the human, and that human is performing the same task, the task to try to identify, am I the person in a system who is allowed to perform the job. So we see here how human oversight, both as a essential requirement, but also as an event for mitigation of risk, is used for compliance. Of course, what's the problem here is that the Charter of Fundamental Rights is really wide, and that let's say standardization is not really, people working in quality management are not extremely familiar with fundamental rights and risks in relation to them. So that's why multidisciplinary team is really required, because different contexts can create different risks to different fundamental rights. So that would be all from me at the moment. Do we maybe have some questions, or we stop here?
Yes, thank you, Professor, so much for sharing all of this. Yeah, I mean, I've checked. We don't have any questions so far. I think, as Ivan mentioned, you opened some really big, let's say, insights to this topic that we can talk about for hours and hours. I would actually encourage everyone to rewatch the webinar. You can do that on our YouTube channel, and then come up with your questions, and you can reach out to us through LinkedIn or our emails, and we'll be happy to then answer your questions, or maybe do some consultation. But this is definitely a topic that will be, let's say, I expect in a few months a really hot one, and people will start even more to get a bit deeper on every part of this EU AI Act. So thank you so much again, Professor, and we hope to see you maybe on some other webinars where maybe we can deep dive into some of these things. I especially like the part of this example that you showed, and these risk level assessments. I think that is the one that is also really important for companies that already have some AI systems implemented to do. And yeah, thank you, Ivan, as well, for sharing your part on the ISO standard. So thank you, everyone who joined, and we'll see you on our next webinars.